On January 12, 1979, in the industrial town of Sekondi, Ghana, Isaac EKEM arrived at WISEWAY Cleaners Limited for what would be his final day of work. As the operator of a powerful hydro extractor, a massive machine with a spinning basket, brake system, and safety interlocks, Isaac was experienced and trusted. He had worked the machine for 18 months without incident. But that Friday morning, something went catastrophically wrong, and Isaac died instantly. Isaac's devastated father refused to accept that his son's death was simply an accident. Convinced that WISEWAY Cleaners had failed in their duty of care, he filed a lawsuit alleging serious negligence. The company had ignored known machine faults, provided inadequate supervision, failed to warn of dangers, and violated statutory safety requirements. But the grieving father faced an impossible challenge. The one person who could explain exactly what happened was gone forever. When he sought witnesses among Isaac's co-workers, he found only silence. Not a single WISEWAY employee would testify on his behalf. Refusing to give up, Mr. EKEM called upon an expert witness, an independent factory inspector from the Labor Department with a master's degree in occupational safety from Birmingham University, England. When this expert examined the machine after the accident, his findings were damning. Both the brake system and the interlocking safety device were faulty. When confronted with this evidence, WISEWAY's managers made a stunning admission. They had no spare parts to repair these critical safety features. Yet when WISEWAY took the witness stand, they told a completely different story. They flatly denied ever admitting to machine faults and instead painted Isaac's death as entirely his own doing. According to their testimony, Isaac had received 9 months of comprehensive training before working independently for 18 months. On the fatal day, they claimed, he had recklessly attempted to stop the spinning basket using a cocoa sack, something he was never trained to do, causing the machine to throw him violently to his death. The court now faced two starkly different narratives: a grieving father with expert testimony about faulty equipment versus a company claiming their experienced employee had acted recklessly. From the beginning, Mr. EKEM's chances were slim, and here lay a fundamental principle that would prove fatal to his case. You cannot win a lawsuit based on the weakness of your opponent's defense. You must win on the strength of your own evidence. The judge carefully examined the evidence and made several crucial findings. The court agreed with the inspector. The brake and interlocking devices were indeed faulty, and WISEWAY had breached their duty to maintain safe machinery. The company had also violated Section 38 of Ghana's Factories, Offices, and Shops Act of 1970, which requires dangerous machinery parts to be adequately fenced. Regarding inadequate supervision, however, the law was clear. Experienced workers like Isaac don't require constant supervision. Only inexperienced workers need direct oversight. Despite finding multiple safety violations, the court was about to deliver a devastating blow to the father's case. In negligence claims, there must be a proven causal link between the defendant's breach and the harm suffered. Mr. EKEM needed to prove that Isaac died directly because of those defective safety devices. The father had presented no evidence whatsoever about how the accident actually happened: no witnesses, no testimony, no documentation. The only account came from WISEWAY itself, and ironically, even their version wouldn't help his case. The court explained the harsh reality of an unforgiving legal principle. If an employer knowingly allows employees to engage in dangerous practices, they can be held liable. So if WISEWAY knew workers were stopping machines with cocoa sacks and did nothing to prevent it, they would be negligent. But Isaac had apparently used this dangerous method on his own initiative, something even the expert inspector had to admit was reckless. When an employee uses dangerous machinery properly and gets injured, the employer is liable. When an employee uses machinery improperly, the employer is only liable if they knew about the dangerous practice and failed to stop it. Since there was no evidence that WISEWAY knew about or condoned the use of cocoa sacks to stop the machine, they couldn't be held responsible for Isaac's tragic decision. Despite all the safety violations, despite the faulty equipment, despite a father's desperate search for justice, the lawsuit failed. WISEWAY was not liable for Isaac EKEM's death. The court, perhaps moved by the father's plight, recommended that the company pay what was due under Ghana's Workmen's Compensation Act, small comfort for a man who had lost both his son and his fight for accountability. This case stands as a stark reminder that in the legal system, emotions don't win cases, evidence does. The law remains unyielding, even in the face of tragedy. A grieving father's conviction that justice demanded answers wasn't enough to overcome the fundamental requirement that claims must be proven, not merely asserted. For employers, it serves as a warning. Be careful what practices you condone or overlook, because knowledge of dangerous behavior can make you liable, even when you didn't directly cause the harm. In the end, Isaac EKEM's death became a lesson written in legal precedent. Without evidence, even the most compelling case can crumble, leaving only grief where justice was sought. The truth of what happened that day in 1979 died with Isaac, and with it, his father's hopes for accountability and closure. Follow Superlaw GH Studios for more. Real stories, real cases, real people.